When we had lots of breaking and enterings, we had something called a clean slate plea. Most of these were young men, and we would offer them polygraph. We had a polygraph operator on staff, and we would grant them immunity on any other property crimes. Didn't include arson, assault, or sexual assaults. If they cleared up other breaking and enterings. Several different occasions in the course of clean slates, we cleared up like 40 B&Es. We'd arrest the other two guys and they do a clean slate, and we don't see that sort of thing anymore, fortunately, and the polygraph is a forgotten artifact. Good afternoon, Ms. Canfield. Thank you for joining us.
Your Honor, of course.
We're going to return to the matter of People versus John Allen Shook. The file number is 252086. FY. Mr. Shook was charged with criminal sexual conduct in the third degree of an incapacitated victim, 2 counts, as a third habitual offender, making that punishable by, I believe, to 30 years in prison. We started a preliminary examination on November 4th. At that time, we took testimony from the complaining witness, Brittany Terry, and Officer Cole Lusby of the Centerville Constant Police Department. Ms. Terry testified about the events of the night in question, which was October 11th, I think was the date. The officer testified. The officer was about to testify regarding statements made by the defendant, but the court felt there was a corpus delicti issue, that there had to be some showing of the elements of the offense before the statements of the defendant could be admitted. The prosecutor had authorized the matter as they felt appropriate, but often in these kind of cases, it takes a while to get everything. So they were waiting for a sane nurse report, sexual assault nurse examiner, SANE, that had been conducted shortly after this on Ms. Terry over in Coldwater, and also waiting for a crime lab report regarding any DNA that may have been found. There was an issue regarding the defendant's bond. I did reduce the bond, which it probably is a good thing because it's been all the way since November 4th to now to get this reset. I was advised again before lunch by Mr. George and Ms. Canfield. They were working on a resolution that would involve a waiver and a potential plea offer in circuit court. Ms. Canfield has handed me an executed waiver. Mr. Shook, here's what it says. I, John Allen Shook, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. We have appointed Mr. George. Here's the operative language. I voluntarily waive my right to a preliminary examination and understand that I am bound over to the circuit court on the charges in the complaint and warrant, which would be the 2 existing counts of criminal sexual conduct, 3rd degree, unless we amend it. Is that what you wish to do? Yes. You had to speak your answer.
Yes, Your Honor.
All right. Are we amending this or just simply binding it as the 2 counts that are on it?
Binding it over as is, Your Honor. If there's an amendment, I will do so in circuit court after further negotiations with counsel.
All right, waived on today's date, which is 2/10/26, held on 11/4/26 partial. All right, the bond in this matter was altered by me in light of the fact that we had to continue to adjourn it. It was present, it went from 50,000 to 5,000 cash or surety, and the defendant has posted it. Is there anything else we need to address regarding the bond?
Just briefly, Your Honor, and I did have the opportunity to speak with Ms. Canfield about this. Ms. Canfield and I have been discussing this over the past few days. The case in general, but more specifically today, my client has been on GPS tether since he bonded at the end of November. I think Your Honor had changed the bond approximately November 18th, and I think he was able to bond shortly after that. It's my understanding that there hasn't been any issue. I've been made aware of any type of issue regarding contact with the complaining witness. My client indicates that having the tether on is causing some physical issues. I think he reported that there's a lot of issues cleaning under that. He had cut himself, and we would just ask whether the court would make a determination about the usefulness of the GPS tether at this point. Obviously, my client would still have the continuing no contact order. If he were found to be in contact in any way, he would be subject to be automatically arrested on that and have his bond canceled. He understands that. I went over that with him today. But, like I said, Your Honor, he has been, from my understanding, compliant. I haven't heard anything regarding any type of issues. We just asked the court to make a determination on the appropriateness of the tether. Thank you.
Ms. Canfield, what's your thought?
Your Honor, does the court have any conditions with respect to no contact with minors under the age of 18 or people who are sleeping? Anything other than I see no contact with Brittany Terry, but that would be my concern if there's any modification. I do have what I believe to be credible information that the defendant is residing in an apartment where there are at least 7 minor children present at any given time. And that, of course, is a concern for me with the type of allegations that are pending here. Granted, this alleged victim is not a minor, but when I have any sex offender, it is a concern. So I would ask that if this is amended, which at this point I object to, but if it's amended, that it not be any supervised contact with children under the age of 18 or anyone who is on medication or sleeping.
I'm going to leave the bond as it is, Mr. Shook. I took a leap of faith and reduced the bond by a factor of 10. Truth of fact is you're bound over on 2 counts of criminal sexual conduct and the 3rd degree as a habitual offender. We live in a small county. You don't live very far away from where Miss Terry lives. And I think it's important to have that additional level of supervision. So defendant's request to amend bond to lift GPS tether is denied. Now, I don't know what's next. I do know what's next. They set what's called a status conference. And that could be, if you guys are going to work out some sort of plea agreement, it could be set sooner rather than later. But in the regular course of events, it's going to be weeks and weeks before that status conference is set. We're moving. Judge Stutzman has to dismantle his courtroom and reset it up in Three Rivers. He's doing some things remotely. So if we're already crunched, we're going to be more crunched. So it could be May or even later before the status conference is set. If there is an agreement worked out, but the parties can simply schedule it for something in circuit court. But for the time being, you posted your bond, you've complied with the conditions of it, and I'm going to leave it as set.
Thank you, Your Honor.
All right, thank you. Angelique, I thought I printed 4 of these, but I only have 3. All right, good afternoon, sir. You Bradley Wade Chapman?
Yes, sir.
Mr. Chapman, you've got multiple cases. See if I can keep them all straight here. File 292629 alleges criminal sexual conduct in the first degree, second degree, 2 counts in the fourth degree. Criminal sexual conduct, first degree is punishable by up to life imprisonment. That's alleged to have occurred on December 16th of 2019. Your attorney in that case is Mr. Arden Mitchell. File 252630 alleges criminal sexual conduct in the first degree, 2 counts, 3 counts, criminal sexual or child abuse in the first degree, 1 count. Your attorney in that case is Arden Mitchell. You're also charged in file 26191 with criminal sexual conduct in the fourth degree. That's punishable by up to 2 years imprisonment. There are 2 counts of that. And your attorney in that case is Rhonda Ives. That is alleged to have occurred in October of 2025. In file 2616146 FY, you're charged with criminal sexual conduct, second degree and fourth degree. That's alleged to have occurred between July of 2024 to May of 2025. And your attorney in that case is Rhonda Ives. Everyone has been working hard on this all day and before today. These matters were set for preliminary examination today. I think I told you last week, a preliminary examination is a hearing where it must be established there's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at a preliminary examination. However, generally speaking, it's the prosecutor's policy that if there is a preliminary examination conducted in a criminal sexual conduct case, they revoke any plea offer. And that's the way we used to do it. So you got an additional issue. You had Mr. Tim George in one of these cases. He had a conflict. So Rhonda.
In this courtroom moment, the judge formally addresses the case of John Allen Shook, who is facing 2 counts of third-degree criminal sexual conduct involving an incapacitated victim, enhanced by habitual offender status. Instead of continuing the preliminary examination, the defendant voluntarily waives his right to that hearing. With the waiver accepted, the case is immediately bound over to circuit court for further proceedings. Defense counsel then requests removal of the defendant's GPS tether, citing physical discomfort, but the judge denies the request, emphasizing the seriousness of the charges and the need for continued supervision.
Ives has agreed to take both of those cases, 26191 and 26146. So Ms. Ives has those 2 and Mr. Mitchell has the other 2. Mr. Mitchell, you're at the podium, so I'll defer to you. I see before me 4 waivers of preliminary examination. Is that correct?
That is accurate, Your Honor.
Mr. Chapman, let me go through this like I did with the last guy. You signed each of these. That's your signature on here.
Yes, sir.
And what the waiver language says is, I, Bradley Wade Chapman, understand I have a right to employ an attorney. In one case, you've employed an attorney, and in the other 2 cases, we have one appointed. If I may request a court-appointed attorney if I'm financially unable to employ one. Here's the language that matters. I voluntarily waive my right to a preliminary examination and understand that it will be bound over to the circuit court in the charges and the complaint and warrant. And is that what you wish to do in all 4 of these cases?
Yes, sir.
All right, we will not be having a preliminary examination in any of these matters. It does preserve the right for your counsel to pursue plea agreements to perhaps resolve these things. This is not an admission of guilt. It's simply an acceptance that the prosecutor could establish probable cause in each of these charges. I know you've been working on a plea agreement. I don't know, do we need to put it on the record here?
Just one portion of it, Your Honor. I have been speaking with the prosecutor on this case, Ms. Camefield, and we are waiving in exchange for the assurance that if we are to reach an agreement, the mandatory 25-year sentence enhancements will be dropped from each of the files.
You agree with that?
Yes, Your Honor, I do. And in fact, I have tendered offers that the waivers to preserve that I would like to place on the record. In addition to that, I would like to note that I have complied with the Crime Victims' Rights Act in consulting each of these individual victims and their parents with respect to the potential resolution that was offered. Again, this is just to preserve the offer with any continued negotiations to occur in circuit court. On file 262630 FY, the offer is to plead guilty to counts 1 and 2, dismissing the remainder of the counts with the noted exception that those will be amended to first degrees without the mandated 25-year minimum. On file 2629 FY, the offer is to plead guilty to counts 1 and 3, dismissing the remainder of the counts. Again, the first degree would be amended to remove the minimum 25. Count or
Slow down a little bit.
sorry. File 26191 FY. The offer is to plead guilty to count 1, criminal sexual conduct in the second degree, dismiss the remainder. And because the same alleged victim is in file 26146 FY, although a different venue, that file would be dismissed.
All right, that preserves the current offer. I don't think we've got a consensus yet, but Ms. Ives, you understand that's the offer as well?
I do, Your Honor.
All right, and you're going to continue to work on this. But that is the current status of the plea offer. It won't get any worse than that unless something happens. All right, Mr. Chapman, these bonds are substantial. They're going to stay as presently set. I'll tell you the same thing I told Mr. Shook. The next step would be to set a status conference, and that could be months away from now. We're moving. They've got to dismantle the circuit court, reset it up. There's a lot of turmoil that goes with that. If something is worked out, any of the parties can move to have this matter set for hearing as soon as a day or so. But in the regular course of events, it may be a while before this is set for further proceedings in circuit court. All right. Anything else we should place on the record?
No, Your Honor.
All right, once again, Angelique, let me execute these waivers. I'll give them to you and you can scan them in and get them back to us.
Thank you, Your Honor.
All right, Mr. Chapman, good luck.
Thank you, Your Honor.
In this courtroom moment, the judge addresses defendant Bradley Wade Chapman, who is facing multiple criminal sexual conduct charges across several separate cases. Rather than proceeding with preliminary examinations, Chapman signs waivers for all 4 cases. By doing so, he gives up his right to challenge probable cause at this stage, allowing the charges to move directly to circuit court. The waiver also preserves ongoing plea negotiations, including the possibility that mandatory 25-year sentence enhancements could be removed if an agreement is reached. With the waivers accepted and the current plea offer placed on the record, the judge confirms that the cases will now move forward in circuit court. The bonds remain in place, and the court prepares to move on as the hearing shifts toward the next matter on the docket.
Good afternoon.
Good afternoon.
Are you Tracy Ellen Wallers Penner?
I am.
Of course, I know you, but I have to identify you for the record. You're here with your lawyer, Jordan Harden. Also present is Angelique Camfield from the prosecuting attorney's office. This case alleges a domestic assault that allegedly occurred in October on the 18th involving your daughter. The matter is set for what's called a final pretrial here today. Ms. Camfield, what's the status here?
It's my understanding after speaking with Ms. Harden that the defendant's going to enter a plea of guilty as charged. There will be no deferral.
That's what you just told me.
If necessary, I'm willing to do a no contest.
Well, let me talk about this, Ms. Wallers. Domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. If you plead no contest, you have to take your gum out.
Oh, sorry.
There's a clean.
I meant to before.
You don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. And I would get the factual basis from the police report or affidavit of probable cause or something else. Do you understand that?
I do.
And are you going to plead no contest to this charge?
Your Honor, we had spoken in the hallway with what Ms. Camfield indicated to me she was planning to recommend to the court as far as a sanction. My client indicated she had no issue with the probation if ordered. I don't know if I guess I don't know where she got the understanding that she wouldn't have to enter any kind of plea today to get on probation. So the offer is you plead guilty or no contest to the domestic violence charge. The prosecutor has indicated to me they're going to make a recommendation for probation with some deferred jail time and some potential treatment for substance abuse, alcohol abuse of that nature. So that's the offer today. If you choose to accept it, we'd enter the plea today, come back at a later date for sentencing, make our argument, provide any evidence we wanted to the court to try to mitigate your sentence. If not, then we leave the matter on for jury trial.
Okay, so it doesn't make a difference if I say guilty or no contest?
No contest, correct, yeah, no contest if you don't have a clear memory of what happened.
I will enter that plea, no contest.
You will plead no contest?
Yes.
All right, let me ask you a couple things. Did anybody threaten you to get you to plead to this?
No.
Promise you anything?
Nope.
Do you understand that if you do plead to this charge, no contest, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that? There will be no trial if you plead no contest.
I understand what you're saying. I didn't know that that was the same as guilty.
Well, it results in a conviction and then a sentence where I could put you on probation, but I don't have authority to do anything to you unless there's a conviction, either by plea of guilty, conviction at trial, or a plea of no contest. So if you do plead no contest, there won't be a trial. Do you understand?
Yeah. Okay.
Or if you had a trial, Ms. Harden would be there with you through every step of it. You'd also have a right to hire a lawyer of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not have a right to testify and did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless they were able to prove your guilt beyond a reasonable doubt. Understand?
Mhm.
A man named Mr. Rhodes was here last month and then earlier this week, and he told me, you don't look people in the eye enough. He said, you're always looking at the damn screen. And I guess I'm guilty as charged. So I've been trying to, instead of looking at the screen over here, looking at the actual people. And so, Mr. Rhodes, I'm trying to do better, looking people in the eye. All right. There is an affidavit of probable cause in here, Ms. Wallers, and I saw it and my heart sank. Your daughter Brielle says that you had assaulted her. Her mother was very drunk and her mother came in and yelling at her, asking for smokes. And then there was an argument and you pulled her hair. And then some other struggle and you fell on the couch and it was unpleasant all the way around. But that's a sufficient factual basis for me. Is that acceptable to you, Ms. Campfield?
Yes, Your Honor.
Jordan?
Yes, Your Honor.
That affidavit was prepared by Sergeant Jeremy Marsh of the Sturgis Police Department.
And Your Honor, I could just put, I believe the affidavit would reflect that this happened on October 18th, 2025 within the county of St. Joseph.
Yes, thank you.
Thank you. I would make it a little bit of an unusual request. Because the defendant is on bond and not supposed to be drinking or using any illicit drugs, she does have an extremely severe alcohol dependency. After this particular incident, when they located her, she was at a 0.32 blood alcohol level. And I've received information from the family that subsequent to that, she was also found unresponsive at home, and when taken to the hospital, had a blood alcohol of 0.57.
Oh my, 0.57?
So that most likely why she was unresponsive would have been most assuredly alcohol poisoning at that point.
That's the highest
I would
level
like
I've
her
ever seen.
tested today.
I don't have anybody to do it. She'll have to either go to Three Rivers. Autumn's not here today.
Darn.
She's at a training conference
Okay.
and she's the only one certified to take a sample. Are you?
Just PBTs.
All right. Well, we could do a PBT.
That would be, if that's what we can do, that
Now,
I'll take.
I know Miss Waller and I know that she was in my sobriety court program. And I spent a lot of time with her. She's an intelligent woman. And that was a few years ago, maybe 8 or more.
It was like.
How long have it been since you relapsed?
Oh, it's just been within this last year.
So you've been sober for 6 years?
15. Was it 2015?
Well, I can look at-
2016. And so 6 years, something like that.
Let's get a PBT. Do you have one here? I think we do. Probation has one. If anybody knows where anything is after the flood. So I know that you can be sober, but this is like danger zone.
Your Honor, if I may request the court also, I think this is one of those occasions where we would need a PSI for a domestic violence charge of this nature.
All right, I'm not opposed to that. Who is Bill Hack to you?
My stepfather.
From the appliance store?
Mm-hmm.
I've known him for years and years and years. Are you employed?
I was. I am not currently.
Where were you employed?
At Meyer.
As I said, when I knew you, you were a very intelligent, capable person when we got you sober. The law requires that I adjourn the matter at least 10 days to provide notice for the complaining witness to be here. The problem is if I do a pre-sentence investigation report, it's going to take longer than 10 days to do that. There's a no contact provision. Who's out of the house?
Riel,
So you're in your own house and she's staying somewhere else.
she's with her aunt, yes.
Who else is at your house?
Her father, Stephen Penner,
And she's your stepdaughter?
biological.
Biological daughter, okay.
My understanding is the no contact is no assaultive.
Yeah. they
Well,
met-
let's take a look.
That's what the bond conditions I have reflect.
All right, well, let's see. Struggles, no contact entered. As victim is 17, they lived in the same house since the incident, no problems.
Right, the
So-
pretrial release shows provision.
So
R.
there is not a no contact provision, and somebody went the extra mile to let me know why they called it that way. So the conditions you do have personally appear for every hearing, abide by any judgment, do not commit any crime while released, make reports as directed, do not use alcohol or controlled substances, do not purchase or possess a firearm, do not have any assaultive behavior against this person who is a minor. But there is not a no contact provision. But the fact that she's probably staying somewhere else. The problem is that when you have an addiction to this extent,
In this moment, the judge addresses Tracy Allen Waller's Penner during a final pretrial for a domestic assault charge involving her daughter. Penner decides to enter a no-contest plea, acknowledging the conviction without admitting guilt. The court confirms she understands she is waiving her right to a trial. The judge discusses sentencing possibilities, including probation and substance abuse treatment, and highlights Penner's severe alcohol dependency, noting prior alcohol poisoning incidents. The hearing also examines no-contact provisions, household arrangements, and the need for a pre-sentence investigation before moving towards sentencing. The court then prepares to proceed to the next matter.
when the judge says, don't drink anymore, you can't just turn it off like a switch. Your body's screaming for alcohol. And so you need to do something about it. Are you in any sort of treatment right now?
I am looking to start some counseling, but I've also had a huge medical mystery that we finally just got solved, and I started treatment for it 2 days ago.
Well, I'm considering medically assisted treatment for you. But do we have a PBT here?
We do not, but we could call Senator Constantine if you wanted us to do.
Would you
that.
please?
Yes.
Tab, do we know where probation's PBT is? We got flooded downstairs and probation is in the wind. One probation aide, they're working remotely till we get their new office space ready across the street. Well, let's pick a date for the sentence. I'm pleased we were able to resolve this. But at one time you were active in AA, you had a sponsor, you had individual treatment.
Yes, it's still downstairs, but it hasn't been calibrated in a long time.
And none of the three, nobody knows how to use it, so. All right, we'll get some assist here. That's our benchmark. Shana gets that.
Thank you.
Thank you. Tracy, I've heard stories of very high blood alcohol levels like that. They had something in Detroit they called the 700 Club. The people that had a BAC, but they were all deceased. That was in their autopsy. And that's generally where 5.7 is. It's in an autopsy report.
Well, and Your Honor, I would just state that's, hearsay that's been provided to the prosecutor. We don't
Yeah,
have
it
any
isn't
verified
evidence in
proof.
this case, but it's frightening. Now, the prosecutors declined to do a deferral in this case. I don't know if you had a previous domestic violence, but I can only do the deferral if the prosecutor consents.
Dispatches haven't sent me signed.
All right.
Take care of that for us.
So today is February 26th. Jordan, are you available Monday, March 30th at 10:30?
Yes, I should be able to make that work.
Anyway, you know how to go to an AA meeting.
Oh, yeah.
When's the last time you went to one?
It's been a while, but I had gone 15 years straight. Unfortunately, my sponsor died. So,
The common denominator in sobriety court people that relapse is continuing to or failing to stay in AA.
and part of it, Your Honor, was I was the lead in bakery, and I could work from 6 a.m. till whatever, or noon to 8:30. And we weren't getting our schedule till a couple days before the new week. So even making a doctor's appointment was almost impossible.
All right.
It was
Well,
very difficult
You,
to have a
my
reliable
hope for
schedule.
you was that you would have been somebody else's sponsor. Did you sponsor others while you were in?
I helped others. I wouldn't say I officially sponsored them. I was dealing with, work and Brielle and
I believe your previous probation officer was Gina Wagner. She was excellent, but she's no longer with us.
can I comment that the other charge that they say I have
Let's take
was from that 2015 DUI.
3. All right, let's take a look.
The basis for not offering the deferral was that
Oh,
OWI conviction had
Well-
tag along child abuse
oh.
with it.
Well, that's in their discretion. I do remember that. Now, we've learned that if you do an OUIL and child endangerment alcohol charge, it prohibits you from getting an interlock device. We've got a guy in sobriety court right now who's doing absolutely great, and he can't get an interlock. So what they were doing back then was taking an OUIL and then a child abuse neglect charge, which wouldn't affect your driving privileges.
In this courtroom segment, the judge addresses Tracy Allen Waller's Penner regarding her ongoing probation and sobriety requirements. The discussion focuses on her severe alcohol dependency, prior high blood alcohol incidents, and compliance with sobriety programs. The judge emphasizes the necessity of continued AA participation, substance abuse counseling, and potential medically assisted treatment. Challenges with probation testing and prior DUI-related child endangerment charges are reviewed, highlighting the complexities of maintaining sobriety under court supervision. The court sets expectations and deadlines leading up to the next scheduled sentencing date.
So if you get the motor vehicle charge under 257, with a child in the car, they will not allow you to get a restricted driver's license with an interlock, even if you're in sobriety court. And we knew this a long time ago, and we've known it for a long time. So very often they will take that charge out of the motor vehicle code and put it under the penal code, a misdemeanor, child abuse attempt or something. So that doesn't affect your ability to get an interlock.
I've said we could get a road officer. to go over
They've summoned one.
Yes.
So that allowed you back then to get your interlock. But so it does show as a child abuse, but it was Brielle the child that was in the car?
Mhm.
Oh my. Set for sentence March 30th. Is the PBT going to show alcohol in your system? Could. Now, you're not to use any drugs or any alcohol. The drugs include marijuana, which is lawful for adults to use for recreational purposes. While you're on bond and probation, we prohibit it. You can take any prescription medication that's prescribed, anxiety medication, pain medication, antibiotics, whatever, you can take that. But unless it's prescribed by a doctor. And I'm serious, it's very, very difficult to just stop. If it was that easy, you would have already stopped. Now you got me hanging jail over your head, which is an extra impetus to stop. But you need to do something. You need to get back into AA. You need to get plugged in with somebody at Pivotal or somewhere else. Perhaps get some medical assisted medication. But you aren't going to be able to hold your breath. Now, what I have envisioned here, the prosecutor's looking for some substance abuse counseling. There's also the women's anger management program, which you're probably going to be put in. But you could get a head start on this by getting your counseling set up in advance between now and March 30th. We had some bumps in the road, I remember, but you did actually complete the program and graduate.
Yeah,
Yes.
it was because my creatine was always low, so which equals positive, and
Mhm.
so I spent many a weekend at the country club.
Well-
and I found out that it is abnormal low all the time, has been for years. Still, I have a thing from every time I've been to Brunson Hospital, I had some surgeries, they've documented it, and it's always low. It's always diluted.
Well,
Also from the type 2 diabetes.
and I don't know if we knew about type 2 diabetes back then,
No, at the time Sturgis Hospital said no, but I ended up going to Fort Wayne and
because we did look into it. You kept having diluted tests, and we've struggled for the entire tenure of sobriety court with dilutes.
Yeah.
And we discussed this 10 years ago. Many programs, a dilute was an automatic jail sentence. Swift and Sure, some of the other ones, a dilute was just assumed to be an attempt to mask the results. And so we do a few, we do some sanctions, then there'd be jail, and then you get out. And I remember we had one guy in particular who we finally did discern he had a serious kidney problem. And he started to get treated for it. He did graduate. All right, we're waiting for local law enforcement. I don't know, Centerville and Constantine share a jurisdiction, so sometimes the Centerville officer's in Constantine. All right. I'm going to ask you to step out with the officer, take the preliminary breath test, and then we'll send you out to the counter to get set up for your appointment for the pre-sentence investigation. I can remember things that happened 10 years ago. Just can't remember what happened yesterday. Very good.
Thank you.
Tracy, that's a good sign.
Your Honor, the drinking was more of like a binge thing. It was not a daily occurrence.
Well, you're binging to the point where you're almost killing yourself. So I don't want you to drink anything.
Okay. I just wanted to let you know that.
All right. But you have to develop a tolerance to be at the level 3s and certainly to be at the other level. So Jordan, I'll ask you if you take your client out to the counter, we'll get her set up for appointment for pre-sentence interview. The sentence will be March 30th at 10:30. Any treatment stuff you get set up before that, bring it, share it with your lawyer because I want to know about it. All right, thank you.
Great.
All right, Ms. Canfield, thank you for your help. We have an important appointment. Yes, well, we'll put that in the file.
Had it signed, we went over it anyways.
At 3 o'clock for Deputy Metz's wedding.
Oh,
Frank asked me if I would marry him on 262626.
all right.
All right. We will, Jordan, thanks for your help.
Thank you, Your Honor.
Who was the officer that came? I didn't get a chance to tell him thank you.
Oh, I don't know.
What was that?
Who was the officer that was here?
Deputy Raymond.
Okay, I didn't get a chance to tell him thanks. I will stop the live stream and we will be back